Welcome everyone to this talk organized by the Romanian Association of Competition Law. The Romanian Association of Competition Law is the Romanian national chapter of the International League of Competition Law, which is an international NGO founded in the 1930s, and it's the only one dealing exclusively with the study of competition law, intellectual property law, and unfair competition law. So it's a very interesting mix of interests, and it brings together people who are interested in these niche subjects from all over the world, from Brazil to China. And we have the pleasure of having some of them online with us. And so we give a warm welcome to our colleagues from all over the world, and we hope that tonight's talk will be useful and interesting. And for tonight, we have decided to bring together a balanced panel of both economists, members of the competition enforcement authorities, and lawyers in order to discuss what is today a very, very hot topic concerning the limitations to mobility of labor and the antitrust review of these. And as you know, we have a panel of 6, 3 economists and Mr. Chirițoiu, who is the president of the Romanian Competition Council, who is both an economist and the person involved in the enforcement of competition law in Romania. We have Mr. Avesu from the European Commission, from the Cartel Division, who is again involved in the enforcement of competition law. We have with us Adrian, who's a lawyer on competition law in Romania. And on the economist side, we have with us from Philadelphia, Professor Marinescu, from University of Pennsylvania. From Paris, we have Professor Jeffers. And here with us, we have the advisor to the governor of the National Bank of Romania, Mr. Vadulescu. And I will introduce them as we go along in order not to delay too long the proceedings. And that is why I propose that we start our talk now. And I think that for the beginning, I would like to explain a bit why this topic was chosen. And it's just that in Europe, for a long time, we've looked at the antitrust review of labor markets as something of a little quirk that was specific to the United States. So we were, at least on the lawyer side, we were a bit surprised when we started more and more competition authorities looking into labor markets as well. And so I think that we should begin by having a look as to how this has begun and why has the Department of Justice in the US taken an interest in these labor markets, and then try to understand how from there we've arrived at the efforts in Europe, and especially at the European Commission's brief on competition law in labor markets. So I will begin by introducing Professor Marinescu, who is an associate professor at the University of Pennsylvania's School of Social Policy and Practice. She was a senior economist at the US Department of Justice Antitrust Division. She has researched and written extensively on competition law in labor markets. She is also an associate editor for the Quarterly Journal of Economics, which incidentally happens to be my favorite economics journal ever, because it was the only one courageous enough in the 70s to publish George Akerlof's study on what he called the market for lemons, on trading with asymmetry of information, which is one of my favorite economic reads ever. Professor Marinescu has testified before the US House Judiciary Committee, the United States Department of Justice Antitrust Division, and the FTC. She has completed a PhD at the School for Advanced Studies in Social Sciences in Paris, a second PhD at the London School of Economics, and she also was an assistant professor at the Harris School of Public Policy in Chicago for quite a long time. So welcome, Professor Marinescu. Thank you very much for joining us. Also joining us is Alessio Avesu, who is works in the anti-cartel enforcement and in the DG competition in the European Commission. He's an Italian lawyer. He is an expert in antitrust law and economics. He has worked with Meta. He was a counsel at O'Melveny & Myers and a senior associate at Latham & Watkins before joining the European Commission. What is probably most surprising for me is that Mr. Avesu loves competition law so much that he would actually trade the weather on his native island of Sardinia for the weather in Brussels, which is a trade-off that not many would do. So I guess competition law means that much to him. So thank you very much, Mr. Avesu, for joining us. I will then begin by asking Professor Marinescu to tell us a bit about how the Department of Justice came to be disinterested in labor markets, and why is that the case?
So thanks so much for having me here. In the US, we have now a long history of looking at the effects of lack of competition in the labor market. And as was mentioned, I was at the Department of Justice Antitrust Division until 2024. So in the founding documents of our antitrust law, it talks about markets in general. And so this includes every market, including what we might call input markets, like labor markets. And more recently, as I discussed in a published article on no poaching agreements, there's been activity, at least since 1995, from the Department of Justice. So again, showing you that this dates now for a while to enforce against no poaching agreements in the labor market as anti-competitive restriction in labor markets. So more recently, in 2021, there was an executive specifically agencies looking at competition in labor markets. And then I joined the antitrust division. And because I'm a specialist of labor market competition, of course, this is something that was close to my interest. And the department as a whole has continued working on these issues, both in the criminal division, which economists are less involved with, but also in the civil division. In particular, we had a merger that for the first time was blocked on a theory of monopsony in labor markets, specifically. The case was a merger of two large publishers, and our winning argument was that the merger of publishers would reduce the pay for authors seeking to obtain contracts for their books. And so there's been a lot of developments around the world. I've been giving talks in other jurisdictions, like in Mexico, for example. So that's really a growing interest around the world. And I also want to just briefly mention that there's growing empirical evidence around some of the effects of those restrictions to competition. And I published recently a review of the literature with Jose Azar, the annual review of economics, if anyone is interested in having a look at that. And finally, just let me close briefly with saying that, you were saying that the US is a quirk. I guess this is continuing to be something that's expanding internationally, and also in the US, we now have a new administration, and the heads of the antitrust division is Gail Slater, and FTC Chairman Andrew Ferguson. Both of them have affirmed the continuity of the action of the U.S. antitrust authorities to promote competition in labor markets. So we will see, for example, Andrew Ferguson has announced a joint task force on labor at the FTC. So we expect to have continuing action in this area in the U.S. Thank you.
Thank you. That was actually my follow-up question, because I saw that well, some of the previous efforts that went to court on the no-poach agreement seemed to water down at some point. And obviously there was this question about the effects of the change in administration, whether this was also one of the things that was going to change. And also, we know that in January, the FTC issued a guidance on enforcement of antitrust law in labor markets, that the new commissioner, then a member of the board, was labeling as well, let's say a bad use of the commission's resources. So that was my next question: whether you think that the new administration is going to continue this trend of investigating the labor markets, and whether you think that this is something that is likely to either be maintained or accelerated, or on the contrary, wind it down.
So as I said, I think, first of all, let me say that it's obvious that between administration, there can be some changes in, the specific emphasis, even within labor. But I think just based on my following the news, for example, if you look at Gail Slater, who's the new head of the antitrust division, in her confirmation hearings, there was this question. I'm just going to read it for you because I think it's interesting. Looking back at the tenure of the last two Senate-confirmed antitrust division heads, Jonathan Cantor and Malcolm Del Rahim. So this was a question from a senator. What is one policy or focus you would continue from each of them, and what is one thing that you would change? And Gail Slater responded, there are clear through lines from the tenures of AJ Del Rahim and AJ Cantor to the antitrust policies of these administrations on issues such as the importance of protecting workers, the risks, etc., etc. So the first thing she said as a line of continuity was the importance of protecting workers. And I do want to also, I think it's important to understand in the US context that Malcolm Del Rahim, who was on the Trump, the AAG for the antitrust division, they were already heavily involved in labor actions. And so it's been in the continuity that when I was there, we continued, expanded our portfolio, but this is not something that began under Biden. And so therefore, there's like a strong bipartisan interest in this issue in the US of promoting competition in labor markets.
Okay, thank you very much. Mr. Aveso, there was no change in administration at the European Commission. We have the same president of the European Commission. Obviously, the commissioner responsible for competition has changed, but the change in the European Commission's policy regarding labor markets had changed before this latest change in the composition of the European Commission. So, can you tell us a bit how this came to be? How came the European Commission to be disinterested in pursuing a competition law review of labor markets?
Yes. First of all, let me thank you for the invite. It's very interesting for me to be here, and very important that we're given a chance to communicate on our policies. So in a similar way as what Professor Marinescu just mentioned, the competition, EU competition law protects competition not only in the sales markets, but also in the purchasing markets. It's always been part of the provisions under Article 101 that both collusion in the purchasing markets upstream and in the downstream market, in the sales markets, are equally protected. So buyers' cartels have always been part of the focus of the European Commission, and the fact, and when there is a cartel that, for instance, in which companies agree not to steal each other's employees or not to solicit each other's employees, this is just as much of a purchasing cartel as an agreement that concerns any other input. I don't know, let's say raw tobacco, and I talk about raw tobacco because there was a precedent in this sector in which the European Commission had already concluded that a similar agreement was a restriction of competition by object. So there's no particular change of policy. There's no change of welfare standards. consumer welfare remains the main standard at the European level, but however, EU competition law has always protected not only consumer welfare, but also the market structure as such. So it means that basically this is one of the rationales why competition law protects competition not only in sales markets, but also in purchasing markets. So there is no paradigm shift towards another welfare standard that might be workers' welfare or similar things. So it's we are just applying the law as it has always been. You might ask, why now this change of policy? There's no change of policy. There is simply a growing body of economic literature that shows the harmfulness of labor market agreements, and of course, these are started in the United States with first the enforcement against. There was an agreement concerning computer programmers in the United States, a case that started in 2010. And led to a settlement in 2014, and then the adoption of the first set of guidance from the FTC and DOJ in 2016. Based on that article, there were some empirical studies, such as, of course, Professor Marinescu has provided a review of literature, but there was, for instance, one article that I quote, which is an article by Gibson showing explicitly on this case of the collusion in the tech sector in the United States, that basically the collusion led to a decrease in salaries of 4.7%. An impact on salaries basically has an impact not only on workers, but has an impact on competition as such, because in general, more productive workers command higher salaries, and the companies that can pay those higher salaries are also the more productive ones. So the expression of competition is the matching of the more productive companies with the more productive workers. And when this happens, the invisible hand of the market is at play, and basically implies that by matching the more productive workers with the more productive companies, those companies become, in general, more productive. They can, produce more input with the same, ceteris paribus, at the same conditions. So this means that basically this has an effect not only on the workers because they have better salaries, but has an impact on competition as such, because, those companies are more efficient and they can produce more efficiently. And this has a general impact on, promoting GDP growth. So it has an impact on the economy at large. And we have seen also that there are many studies. For instance, Professor Marinescu's work that showed that there's a high labor market concentration. For instance, in France, she studied the market in France, showing high levels of market concentration, and also studies during the lastly during the Biden administration. For instance, a study by the U.S. Treasury. Showing that, for instance, the share of profits that goes to labor has decreased over time, and also that market power may in fact be inherent in the individual relationship between an individual worker and an individual company that employs him or her. So basically, given that there is market power, it's important that antitrust enforcement is strong in order to contrast this market power and possible agreements that can tend to increase that market power. So basically, just to summarize, why the enforcement at this point in time? Because we already had the legal basis in order to leverage this, and the economic literature has progressively shown that these type of agreements are problematic and are more widespread than the Commission used to think. And that's why we thought it was a good use of the Commission's resources to, bring enforcement action in this space.
Thank you. Before we go on, I forgot, of course, to say something very important, which is that everyone who watches us online can write in their questions on the website, and anyone here present can ask questions as well. We already have received some questions that I will try to wiggle into the discussion as we go along. So please let us have your questions, and we will try to address as many as we can during the event, and maybe some even after. Professor Marinescu, I come back to you regarding what Mr. Avesu was saying, that this enforcement of this type of limitation concerns the consumer welfare beyond that of the workers themselves. And this, I have to ask if your research points to that, because for me, as a non-economist, it's a bit counterintuitive that if the cost of an input for a producer is lower, then the price of their product should be lower. So consumer welfare would be better served by a cheaper product, which is, the way or one of the explanations that competition authorities have used in order to guide their enforcement. Why would this be different?
So first of all, let me say that it's an important principle for U.S. enforcement that we look at one market at a time. So if there is a competition problem in the labor market, and one thing I should have mentioned is that we have the 2023 merger guidelines, which here we're not talking about merger specifically, but it manifests a broader principle, which is that when we investigate labor market competition issue, we're looking at how competition in the labor market is distorted, as Alicia was saying, and how a lack of competition, for example, is going to lower wages and prevent the proper allocation of workers into jobs. So that's one thing. But this being said, as an economist, of course, we can talk about effects beyond the labor market. And I think one way to think about that, first let me talk about theory, which is if you think about our basic oligopsony framework, the idea there is going to be that when you have greater concentration in labor markets, you're going to tend to see lower employment and lower wages. Now, what does lower employment do? Lower employment decreases production, right? So for a certain number of inputs, you can produce less output with the same employment. And so therefore, this would tend to also increase prices in the product market, generally speaking, due to a spillover effect from the labor market to the product market. So again, there's a lack of competition. We're not employing enough workers, so we're not producing enough. And that increases prices in the product market. And actually, it's really interesting because there's an empirical study looking at enforcement in the product market and showing that when cartels are busted in the product market, it also increases employment. So actually, it kind of goes both ways. As production ramps up, when the cartel stops, there's also more employment of workers. So I think there's reasons both theoretically and empirically to think that there is this correspondence. But this being said, in US law, we don't need to show an impact on the product market. When we're looking at the labor market, we're investigating it, for its own sake, to look at how competition works in the labor market.
Thank you. So,
sorry, if I may chip in on this point as well. You raised a very important point, which is the pass-on of lower wages in the form of lower consumer prices. I mean, is that something that can realistically happen or not? And in this point, on this point, I also under EU law, there's a similar principle than the one that Professor Marinescu just mentioned, i.e. when we look at efficiencies, we look at markets individually. We don't look at cross-market, so for instance, we look at each market individually. So basically, it wouldn't be possible to take into account possible, effects on the market in the labor market and possible spillover effects in the downstream consumer markets. And this is also provided under the Article 1013 guidelines that concern efficiencies. And those same guidelines also provide for an additional principle that when there are, for instance, cost savings that derive from the mere exercise of market power, those cost savings cannot be taken into account in order to claim possible efficiencies. And this is exactly what happens in the case of labor market restrictions. So if by exercising market power, i.e. by colluding, by getting together, the companies are able to save some money because they can artificially depress the salaries, those cost savings derive from an exercise of market power. Therefore, those cost savings cannot be taken into account in order to claim possible efficiencies. So this was just to provide you a bit of the framework that we would use, and it's very similar, to the one that Professor Marinescu just mentioned.
Okay, thank you. And to close this bit and to create a segue to the next section, I want to ask, is this valid for all types of limitations to mobility of labor? Because we're discussing, and I understand that we can delineate between the horizontal aspects, which by the definitions that we've discussed prior would cover wage fixing and the no poach in the two forms. So basically, we're discussing when the competitors collude either to fix wages for their employees, or not to hire each other's employees, or not to actively pursue each other's employees. So these would all be horizontal aspects. But then we have the other aspects, which, yeah, I understand it's debatable whether they're vertical or not. But we have the situations where I know that many of our clients have non-competes in their employment agreements, especially with senior employees. Then we have also seen situations where the employees have a type of non-solicitation with their employees post-employment, barring them from going back and soliciting their other employees. Or we have the situations where a company providing a service to a client agrees with that client in that contract that the two shall not solicit each other's employees who are working directly in that for the provision of that service. So would this be covered as well? Would this create the same type of effects of distortions in the labor market that you were discussing? Professor Marinescu, if you have a...
Sure, absolutely. So I think it's important, one important principle to take into account is that businesses and people might have multiple kinds of relationships, and they might be vertical in some market and horizontal competitors in other markets. And just because they are vertical in some market doesn't mean that therefore makes it all good if we're also horizontal competitors in some other markets. So for example, when the agreement might be, let's say, a non-compete, and it says that you cannot compete with me if you start a new business. You cannot compete with me. That's horizontal, arguably, in that sense, about the future competition that is being averted. So you have to distinguish. Of course it's very fact specific. It depends on what we're talking about. But the question, but it's nevertheless important to be able to kind of focus on the horizontal aspect, because that's going to be part of the analysis. Then you can also have situations where, for example, in the US, when we're looking at something like a no poaching agreement or other types of agreements, you might ask whether these are ancillary, right, to some other relationship. Right? That could be vertical or some other relationship, and whether they are really necessary for that relationship. And that's where the analysis can take into account potentially other types of relationship and whether this restriction is excessive, given the nature of the situation that we're dealing with. So let me give you an example with the non-competes. So generally speaking, now we have a lot of literature on the impact of non-competes, and generally they tend to reduce workers' wages and worker mobility, which on the face of it seems to be, adverse effect on competition in labor markets. But of course, we understand that businesses will say that sometimes there might be legitimate business interests that are trying to be pursued by, especially you mentioned senior employees. So I want to focus especially on those senior employees. There's a recent article that just came out by Xi in Econometrica, which is one of the top journals in economics, looking at restrictions, non-competition agreements for CEOs. So, we're really talking here top of the chain. And she concludes that essentially these kinds of restrictions are going to be, and this is economics, right, not legal, but from an economics perspective, they are ultimately welfare decreasing. They're not a good idea for the economy. And this is because, as she found in her paper, the adverse effects on other competitors, other firms want to take the CEO, and where the CEO likely would be more productive are unable to take the CEO because of the non-compete. And in the end, the adverse effects on competing firms who want to hire the CEO are bigger than the benefits of having the non-compete to the firm and to the CEO themselves, which in that paper, the CEO is compensated themselves for agreeing to a non-compete. So it's really interesting paper because it shows you that it's not all between the two parties. So here, the CEO and the company that they're working for, it has effects more broadly on the market in terms of other companies missing out on a great CEO who might be a better match for the needs that they have. And so that kind of tells you that there are, many aspects to the non-competes that go beyond the employee and the company. And so in general, I think an important thing to consider is that sometimes, again, there might be legitimate employer interests, but that can still lead to harm for other competitors. And also, it's really important to have this principle of less restrictive alternatives. So in other terms, the non-compete, the way it's written, is it clearly a precise tool to protect a very specific interest that we can show, or is it much broader than that? And that, for example, the duration is too long, the scope is too broader than what might be, legitimate to protect a very specific interest. Sometimes as well, there are other ways to protect interests, for example, non-disclosure agreements or trade secret laws, if it's an issue of confidentiality, that can also be used. And so in that sense, we have to, think about, is the non-compete, well-tailored non-compete given the specific interest at play, or is it too broad and overly restricting competition in labor markets in all these potentially harmful ways that I just described?
Thank you. So, Mr. Aresu, how does the Commission plan to deal with this variety of types of restrictions to limitations, not restrictions, limitations to labor mobility? How does the Commission, do you plan to use the same measure for all of them?
First of all, we think that so we need to draw a very clear distinction between two things that also Professor Marinescu was talking about right now. One is whether the agreement is vertical or horizontal. And the second thing is whether it could benefit from being qualified as an ancillary restraint. And then the third point is, whether there's a restriction of competition that concerns a non-compete versus a no-poach or non-solicitation agreement. Let's take them in reverse order. Just to give you a definition, non-compete agreements are agreements in an individual employment agreement between a company and an individual. Under EU law, competition, under Article 101 in particular of the Treaty on the Functioning of the European Union, we can only go after agreements between what in legal parlance are undertakings, so between companies. It means that basically it's generally outside of our remit to go after individual agreements between a company and its employees. This, as a rule, would put non-compete agreements outside of our remit. This doesn't mean that those agreements are not cannot have detrimental effects on competition. And the economic literature has shown that they probably do, but they as a rule there we cannot go after those agreements under Article 101 of the Treaty on the Functioning of the European Union. Think of two companies. I was saying one of them is a staffing company that provides temporary workers, and the other one is the user of those temporary workers, right? In this case, you would also have a vertical relationship. And we do not exclude that this type of, and we do not exclude that, for instance, an agreement between those two companies not to poach the workers that are provided by one company to the other might well be, might qualify as an ancillary restraint. However, as Professor Marinescu was mentioning before, there must be a very clear inherence of the type of restriction with the type of agreement. So if there are two companies, for instance, if the agreement concerns, I don't know, let's say IT engineers, computer engineers, the agreement, that the provision will have to concern those specific workers, because otherwise, without that provision in the contract, the contract would not be entered into in the first place, and therefore you would not have an agreement that potentially is pro-competitive. But for instance, it would not be considered an ancillary restraint because it would be disproportionate. An agreement in a provision in an agreement that concerns IT workers that instead concerns all the workers of the two companies, regardless of the category of the type of work that they do. So there is a way for this type of restraints to be compliant with competition law, but they must comply with very strict requirements of objective necessity and proportionality, which are provided under the ancillary restraints rules of the European Commission, the precedents, and under the MasterCard case law in particular. Okay. I hope I covered it.
Thank you very much. I'm going to go now because Professor Marinescu mentioned the approach in the US regarding the non-competes. And we are very happy to welcome today Professor Jeffers, who is an associate professor at the Department of Finance at the HEC in Paris. She has a BA from Yale. She has taught in she has her PhD from Wharton from the Wharton School in Pennsylvania. She has worked as a professor in Chicago before going to Paris, so she did the reverse. She changed to better weather here on the continent. But Professor Jeffers, who also holds the Rothschild & Company Chair for Data and Impact Investment at the HEC, she has written and studied extensively on the antitrust treatment of labor markets, and she was instrumental in the FTC's non-compete ban from a while ago, which was actually a bit refined to exclude specifically senior employees. So Professor Jeffers, if you can hear us, I don't know if...
Yes, I can.
Yes. So how did this come to be? Because Professor Marinescu was just telling us that the senior employees would, on the contrary, look more likely to be within the scope of the non-compete. Why would the FTC eventually decide to exclude specifically those senior employees? And how did the FTC treat these non-competes, and why did the court eventually stay the wide ban on non-competes? What does your research say? And thank you very much for joining us.
Oh, you're very welcome. Thank you for having me. So that's several big questions. Let me try to take them in order. Why exclude senior employees from the ban on non-competes? I think this goes back to the research that Professor Marinescu mentioned on the effect of non-competes on wages. This is more of a concern for lower level employees. So there is a sense, and to be fair, I'm not thinking of a specific research paper that has documented this in detail, but I will speak in my capacity as generally having done the research and read the research in these spaces. There's generally a sense that for the most senior employees, they have the capacity to hire, really, if you're thinking of CEOs, essentially, CEOs very often have non-compete agreements, but they also, when they are joining a firm and negotiating their compensation package, typically are working with lawyers to advise them, have substantial bargaining power to negotiate over that compensation. And so if as part of this, they agree to a non-compete, there is a sense that this is done as part of a broader negotiation in a more aware way than for your average entry-level worker. And so for this, there is actually, there's a very influential survey paper that was written by Evan Starr and some co-authors looking at the prevalence of non-competes in different occupations, but also that asked individuals if they knew whether they had a non-compete in their contracts and if they had negotiated over non-competes in their contract. And I don't remember the exact number, but the majority did not negotiate over non-competes. So I think that that's part of the reason why, so there's a sense that that is true for entry-level or maybe mid-level workers, that they do not negotiate over the non-competes, whereas if you're talking about the most senior levels of employees, they are negotiating. And then the second part is the compensation part. So the sense that if you are a CEO, a high-level manager, the impact on your wages is either lower or something that you negotiated, whereas for an entry-level worker, the impact of not being able to move because you are bound by a non-compete is substantial. And in fact, I think the way that the FTC had worded their proposed ban was there was a salary threshold.
Yes, there was I think it was something like 130,000.
So I've answered one of your questions.
Yes, thank you very much.
The second question that you had, what was about why this was stayed by the courts, or so?
So we can deal with that then. Why was there such pushback? Actually, I won't have you comment the court's decision, but actually you can comment the decision. You cannot comment the intention because we don't know it. But I would like to understand why was there so much pushback on the non-compete, because obviously there have been the no poach cases, and I remember that in the Silicon Valley no poach case there was quite some transparent and very clear correspondence between the CEOs of the companies.
Absolutely.
But there was no excessive pushback against the enforcement against no poach, but there was with the non-competes. Why do you think the difference? Do you feel that American businesses felt that, if you had to draw the line, you had to draw the line before the non-competes, that they felt that these actually provided them some significant value that they needed to preserve?
So I think there's a very fundamental difference between the no poach agreements and the non-compete agreements, which has been alluded to already by Professor Marinescu and Mr. Aresu, which is that no poach agreements are between employers, whereas non-compete agreements are between employers and employees. And that's a critical distinction, because that means that the non-compete agreements are, you could argue that they're a private ordering problem. Right, so they're, in principle, the workers whose. I'm sorry. Can you still hear me?
No, I'm sorry. The monitor will stop if we don't press a button. It's telling us, and there's a timer. It's quite distressing to see a timer going down nowadays. So it's.
So it actually goes back to this question of why. It is actually related to this question of why maybe CEOs and senior level employees were carved out. Is in principle, if you have a private ordering problem, if you have an employee saying, okay, I agree to this, right? I'm signing my employment contract, and there is a non-compete in this employment contract. Some would argue, I don't necessarily agree with this, but to represent the argument, some would argue, well, this is an agreement that they have entered into, and who are you to intervene and say, well, you're not allowed to sign this agreement? This is very fundamentally different from saying companies are agreeing with each other on something that affects their workers and not letting their workers know about it, right? And workers don't have a say. In no-poach agreements, workers don't have any say. And so I think it's a much clearer case there to say, well, wait a minute, you're talking about something that fundamentally affects individuals' ability to access the labor market. You can't cut them out of that decision, right? So I think the antitrust case, from my perspective, I'm not a lawyer, but from my perspective as an economist, I think the antitrust case against no-poach agreements is much easier to make, which is not to say that it's not possible to make it for non-competes, but I think then it becomes maybe a little bit more nuanced. And this is why there is more pushback for non-competes, is because firms say, wait a minute, this is now you're interfering into an agreement that we entered into directly with the workers. So you need to have cause to interfere and to tell us we aren't even allowed to enter into these agreements. Okay, there are potential reasons why, so if there's an economic interest, for example, and research has shown that non-competes affect the entrance of new firms, right? So you can say, look, it's detrimental to competition to have non-compete agreements, at least as broadly as they are, for the most part, currently written. But it does require, I think, an extra step of argument.
Okay. And does...
And I see that Joanna has a comment here to make, and I'd love to hear what she has to add.
Yes, Professor Marins, I don't...
Yes, yes, can you hear me?
Yes, we can. Please, go ahead.
Very quickly, just wanted to say that regarding the limit in pay, as Jessica explained, there are some reasons, because the higher paid employees are better able potentially to negotiate. So that's part of the reason why. But interestingly, there are states as well in the US that have implemented these bans, and sometimes they also have this limit in pay. And in particular, Washington State, which is a US state, has done that, and Evan Starr and co-authors actually have looked at the impact of this cap. And what they found that I think is fascinating for our discussion here is that employers, so above the cap, you are allowed to have a non-compete. Below the cap is not enforceable. Like, you cannot, force the employee to do anything if you pay them less than the cap, right? So therefore, you would think that if employers really care about the ability to go after people for non-compete, they could bump the person by $1 just to be above the cap. So now they are allowed to limit that person's mobility. And so what they found, however, is that doesn't happen. On average, employers, even if they try to look at specific categories maybe that are more sensitive, you don't see employers being willing to bump up just a little bit, right, to be in that zone where you can actually enforce the agreement. So the paper goes at length to explain why that might be the case, and essentially they interviewed lawyers and found that plausibly it's very rare, in fact, that companies ever want to enforce this. Number one, it's just so rare that there's not paying a lot of attention to it. And secondly, there's other ways to achieve some of the things they want to achieve, like I was mentioning earlier, non-disclosure agreements, etc. So I think this is an interesting case, just showing in practice. Again, doesn't mean it could never happen, etc. But on average, employers there were just not willing to pay workers, again, just a little bit more just to get over that limit so that now they could enforce non-competes.
But an important clarification here, if I may, and correct me if I've misread their work, but I think in terms of companies not, when we say that companies don't care about enforcing non-competes, it's in the sense that they get the bulk of the effect just from the deterrence, right? Just from having non-competes in the contract. So there's also work that I think Matt Marks has done looking at the existence, the widespread use of non-competes in California, which is a state that does not enforce non-compete agreements. And I have done work as well, which isn't yet publicly available, but hopefully soon, look at court cases surrounding non-competes. And it's very often, companies don't need to go all the way to actually having a judgment issued saying, yes, the non-compete is enforceable in this case and we are enforcing it. A lot of the action, so to speak, can come from just either, having it in the contract, issuing a a letter to say, you're in breach, even if there is no actual merit to the, to this, even if in principle the non-compete would not be enforceable, but all it takes is for firms to have, more like deeper pockets than employees, and employees are very quickly deterred from pushing too far. And again, this comes back to the question of salary, because that's going to be true for a low salaried worker, for an entry-level worker. It's going to be less true for a CEO, who then maybe has the deeper pockets, has the lawyers to push back.
Thank you. Yeah, I think that also goes to explain why when the FTC came out with this notice, they actually required employers to send out, to inform their employees that their non-competes in their contracts would no longer be enforceable, so as to not be perceived as a deterrent when it's clear that it wasn't going to be used. Thank you. And going to Adrian, who's a founding partner of 360 Competition after doing serious time in competition law. He's been doing this for 20 years, and he's been representing all sorts of clients, and successfully to some extent, sometimes. I think we'll have President Kivitso's dissent on that one, but we'll wait. So recognized by all the possible and impossible catalogs and tops and characteristics and publishers, Adrian is a good friend of ours and a member of Arcon. So Adrian, as the first lawyer speaking for the employer, how do you feel? Should there be more leeway in how these limitations are pursued? Because I know both of us, we have clients. Our clients have these different types of non-competes, and they are sometimes required to agree not to solicit their clients' employees as well. I know that we both share the same experience with ancillary restrictions. I think never, ever, ever. So I think that would be a difficult one to pull. What would be the other ways that you can balance out the needs of the employers with what we're hearing with the fact that employees should not feel unduly restricted?
So first of all, it's a pleasure to be here. Paul mentioned that I've been a competition lawyer for nearly 20 years, and some of them have been spent here at Mushat and Asociații, and they've been the best of them. So always a pleasure to come back here. Well, the first thing that I'd say is that it's a very slippery slope when you start with labeling things as restrictions by object. We can start with something that we all agree upon, that naked, no-poach agreements are bad, and then it all goes downhill very fast. Arguing that every single no-poach agreement is anti-competitive by object turns everybody into a competitor? Are we all competing for the same input on the market? Are we looking for the same lawyers, the same accountants, the same IT specialists? Does it matter if our no-poach agreement covers very highly skilled people working together on a project or covers everybody? Does it matter if it extends over a period of 10 years or 6 months or by the time the project is completed? I'd argue that it does. And I believe that we used to talk about cartels and restrictions by object as we do about elephants. You don't have to describe an elephant. You'll know it when you see it. Nowadays, everything is an elephant. So we have cartels which are labeled as cartels, but they're still legal if you have a market share below a certain threshold, like joint purchasing. I would see a resemblance between a no-poach agreement and a joint purchase agreement. We agree to pay the same price on certain input. If we're small enough, I don't think it matters. I'm a lawyer. I did some very basic economic courses, so I wouldn't, I can barely understand what the economists are saying, but I know that there are studies which have showed that in the case of skilled workers, and one of them concerned actually the state of California because it was brought up. So California, Georgia, Illinois, Pennsylvania, if you had physicians entering into non-compete agreements, after 10 years, their wages were up by 70%, as opposed to 35% for those who hadn't entered in the same agreements. Because when you know your employee is there, you are going to invest in the said employee. You are going to do your best. And I'd argue that this view that we have, and it's a very, very easy view to sell, the employer refuses to raise the wages. I don't think that the employer sets the wages. I don't think that we have the big bad employer who refuses to pay a higher wage. Sometimes the market sets the wages, and this could be an answer to the question: why didn't the employers go over the limit for the non-compete agreement? Because it just wasn't worth it for the job, perhaps. If it's a 5% increase, maybe. If it's a 25% increase, then no, maybe it's just not worth it. And there was another, you know what they say about economy? Does it work it works in practice, but if it doesn't work in theory, it's not good. There was a very good and interesting case in the US as well, when the Attorney General basically stopped the no poaching clauses in the quick service industry in Florida and Rhode Island. What does that mean? We had, I think, around 18 or 20 franchises in the fast food sector, and they had agreed not to poach their employees. And basically, it all changed from one day to another. The no poach agreement stopped being enforced, and of course, we had a perfect case study. And we found that there was a lack of significant increase in wages, and the methods involved could detect a 1% to 3% increase in wages, and they didn't detect even that. And there was a distinct lack of effects on market concentration and mobility of workers. So in theory, things are simple. In practice, they are not. So coming back to your question, I think that we have a very good starting point. Naked, no-poach agreements are restrictions by object. Fair point. But then you have to look at it, because it's very, very rarely that you will see in practice a naked, no-poach agreement. And of course, I'm very skeptical to our chances of success if we are to argue that it's an ancillary restraint, or that the conditions of 1013 are met. Funny enough, we heard that if you make certain savings as a result of your market power, that you can't argue that it's a positive effect that you passed on those savings to the consumers. But then again, 1013 says that the savings you made have to be directly related to the infringement, and the infringement has to be essential for the savings. So I think it's a catch-22 type of thing, which basically nullifies all your chances. So in the interest of equality of arms, let's say, I would argue that we can start by having an object restriction, but then we have to look at all the details and see if the restriction that we are dealing with is actually capable of having anti-competitive effects. And this goes, I'm more interested about the law in competition law. This goes to what the ECJ said in Carbon Care, that you have a restrictive interpretation of by object. So we shouldn't hurry too much to label everything by object.
Okay, thank you. I've noticed, that's why I'm turning, because that screen is a bit too small. I was expecting Mr. Avesu to have a hands up, so I'm going to turn over to him. But before I do remember that Mr. Avesu said something about the precise delimitation of the employees concerned. The very precise delimitation of the employees. And I think that we can agree on that you need to find both the limitation and to study effects on that very limited class of employees, because you cannot, if you extend it, then you will find these restrictions far too often. And I also take the opportunity now to raise one of the questions that was posted online by one of our viewers, and she is saying, concerning no-poach agreements between companies, I believe one of the paramount concepts that needs discussion and most likely will be developed by competition authorities is the concept of agreement. In situations where there is no evidence of an agreement or understanding between companies, simply for alleged market reasons, companies do not hire workers from each other. For example, because they are clients or suppliers of each other, because they believe the workers' profile does not match. Can this be an agreement? And I think that this also goes to the presumptions that qualifying a restriction by object allows, because it inhibits any kind of further look into a proper market definition, into whether there is or is not a proper agreement. So I think I do understand why the need for a quick policy response to this would arise, but how does this get balanced with the needs of the business and the guarantees for the other side? Mr. Avesu, please.
Yes. I think Mr. Stair mentioned the fact that joint purchasing is allowed. Yes, joint purchasing is allowed when it's transparent vis-a-vis the companies from whom they're buying. So this is also in buying alliances in supermarkets. This is allowed because this is transparent vis-a-vis the companies from whom those buying alliances are purchasing. When there is a secret cartel between companies that get together and secretly agree not to steal each other's employees or to fix wages, this is a cartel, and a cartel is a restriction by object. It's very simple.
And just a short point. And if it's not a secret cartel, if they agree, if it's not secret, because the counterpoint is
bring me an agreement like that, and we discuss it. I mean, let's discuss. This is a type of. I'm open to discussing the details, but if you tell me that there's an agreement between companies that agree, for instance, to purchase together a certain input, it may qualify as a buying alliance, and in that case, it's not seen as problematic, and it would not be an enforcement priority for us. So every case is different, and but the basic rule is if you have a secret agreement between two companies that decide not to steal each other's employees, it's a cartel and it's a restriction by object. Then, if you have a similar agreement, despite being secret, for instance, is between two companies, as I said, of which one is a staffing company and the other one is the user of those temporary workers, and they agree not to steal each other's employees for the duration of the contract, and the scope, the personal scope, is limited to those specific employees that are provided from one company to the other, then we might be able to discuss it. Then it might qualify as an ancillary restraint, but it needs to be objectively necessary and proportionate. So, I mean, we can discuss it on a case-by-case basis, but, I cannot give you a blanket exemption.
Okay.
Can I jump in on this?
Yes, I was just going to ask you to. Yes, please.
All right. I had initially raised my hand to make very much the same point, at least as I had other points as well, but that essentially I cannot think of an economic justification to have a limitation of mobility on workers that is not communicated to the worker. So if there is the example of a joint project makes a lot of sense. You're correct. There may be a justification there to have a limitation of mobility, but there is no justification to not have that communicated to the worker. And so I think for me, that is kind of what maybe we can at least agree on is that there should not be agreements between employers that are not communicated to their employees. And in fact, that also applies to the audience question, which was what happens when there's a unilateral policy not to hire from another company. I think in those cases as well, this should be communicated to employees. Perhaps you can have a policy to not hire from clients, but this should be communicated to employees so that they have the capacity to make their own employment decisions based on that information.
Okay, thank you.
Sorry, and if I may complement also on
please.
the question that we received from the audience, what we're talking about is cases in which you have email exchanges that say, we agree on something. If there's a unilateral policy, it's not an agreement. And if it does not qualify as a concerted practice, there's plenty of case law that says what is an agreement, which is a formalized agreement, request an agreement between two companies, or what is a concerted practice. If there's a unilateral conduct, that unilateral conduct is not relevant as a cartel. So we cannot go after it unless, of course, it could qualify as some form of abuse of dominance, but then you would first have to prove dominance. So you would have to first prove that the company is a market power. And, in that case, it may or may not qualify as an abuse of dominance. But, let's start from the point that if you have no agreement and if a company unilaterally decides not to hire from another employee, from a competitor, it's its decision. They're free to do it. However, for instance, it might be that, as a company, I unilaterally decide not to hire from any workers from my suppliers because, I want to keep peace. I don't want to, create bad blood or whatever. However, very often, these type of practices very quickly become agreements. There's an email from the supplier that says, hey, what are you doing? Why are you going after my people? And the other says, I'm sorry, I will stop doing it. That becomes an agreement. An agreement is not, it's not permitted. So just to give you an idea of what type of practices we've been looking at.
Yep.
So first of all, congratulations for this event and how it's going on. Thank you for the invitation. It's clear that you have a really very well-rounded forum of people and very prepared with a lot of expertise. Mr. Adrian said earlier that the big bad employer doesn't set the wages, the market does. Who is the market?
Well, before we got cut off the first time, there was the talk about the invisible hand, So there's an offer and there's a demand, and usually you get paid what the employer affords to pay you. If he doesn't pay you enough, you will leave. If he doesn't pay you, if he pays you more, then he'll lose money. At a certain point, he will have to align his wages with the rest of the market. And while I agree that perhaps it's a stretch to say that every employer pays all that he can possibly pay his employees, that there might be a margin in there somewhere for him and for his troubles. I don't believe that solution is to say that I don't believe that the cause is the no poach agreement. So the lack of mobility of employees is what keeps the wages low. And of course, we have collective bargaining agreements. It's a very peculiar sector where you have a lot of means to negotiate wages and so on. So I don't think that the agreement between employers not to pay more their employees is what is keeping the wages down.
Well, actually, and this is where I was going to go to Mr.
I thought you were going to say, I believe it does.
I was going to go to Mr. Radulescu on this because that was actually my question, let's say my unclarity on this, which is in a static analysis of the relationship, you would think that the employer has a maximum that he's willing to pay, and that depends on his total cost and his margin and everything, right? So basically, you look at T0 at the static, and he says, look, because I want to make, because my minimal margin is 1%, I am open to paying 99% of the price.
Employers sue their employees for breach of non-compete. That a lot of these cases would be around, well, we trained you, and you now have this like special skill that that we trained you for, and you took this to the competition. And I see maybe 5% of cases are about that. A lot of cases are about, broadly speaking, intellectual property, but a lot of that takes the form of like client lists and market knowledge, which to your point is semi-general knowledge. It's not, it is training maybe, or it is something that you learned on the job to some extent, but it's not something that we think of, the firm invested a lot into that human capital
skills,
training that they wouldn't, into your skills that they wouldn't have done otherwise.
And it might be protected as a trade secret, by the way. I mean, if you have, customer list, for instance.
Right. And you can have non-solicitation in the sense of, you can have non-solicitation agreements in the sense of you're not allowed to solicit clients.
Yeah.
Right.
Yeah.
So there are, and I think with Ioana, we're maybe in agreement that you can have more tailored, we're not saying that, you should not have any protections on firms' investment and intellectual capital, but a lot of the provisions that we're talking about here are generally used in very broad stroke ways because they can, this is my sense, because firms can kind of get away with it.
They can do it, yes.
But really what they need is something that is much more tailored, and the economy would be better off if they were using more tailored agreements.
Yeah.
Okay. I'm sorry, you were cut off for a few minutes, so we didn't actually.
When they mentioned that the end of the no poaching agreement in franchising didn't increase wages, because there's two studies I looked at by Lafontaine and Kalachi et al. Both of them found that actually it did increase wages. So I'm not sure what study was referenced there, but that was perfect.
I also wanted to push back on that, but same thing. I was trying to keep my remarks shorter.
It wasn't the highest, priority comment, but that surprised me.
Or even on the mobility point. I mean, I think at this point, if there's one thing that we understand well, is that there is an effect on mobility.
Yeah, we were, so this part of the world was cut off for a bit from your end, but.
Between us.
No, I bet. I hope our tech will also give us the recording, so then we can have a second episode where we ask the questions. But we were actually starting on a point that was discussing as to how are employers actually fixing, or how are employers setting the wages for their employees? How will they? And Adrian was saying earlier that there's actually less power than we imagine for the employer. And this is where I wanted to step in a bit and to also ask Mr. Badulescu how does himself and the National Bank see this in Romania, because what I find in talking to our clients is that the feeling, the overarching feeling in Romania is that the market is very tight. And actually, the labor market is very tight. And actually, this is something that I also saw in Executive Vice President Munzatu's statements recently, that Europe has a deficit of highly skilled workers and that more should be done towards this end. So I think that what our employer clients feel is that they have far less leverage in setting those wages, and they simply have a limited pool of absolutely essential input that they need to take in, which are highly skilled workers. So basically what they do is that they increase they overstep their ability to pay the wages, and they hope that they can pass on everything into the final price of their services to their clients, which actually causes a bit of a disparity between the level of wage increases in Romania and the level of GDP growth and productivity. And I was actually looking at this and seeing that while wages have grown for like year on year 12% in euros, and I think 14 or more percent in lei in Romania, GDP growth in Romania was 0.9% last year, and productivity growth was even less. It was 0.6%. Does this disparity cause an inflationary pressure that the National Bank would be interested in or would be concerned about? And I will, before I need to introduce Mr. Badulescu, who has been a director in the National Bank for a long time. He's been a director of the Direction for Financial Stability, for Audit, for Monetary Policy. He's been a CEO of several banks, so he's seen it from both sides. And now he's a trusted advisor to the governor of the National Bank, and a very well sought after speaker for conferences. So thank you very much, Mr. Badulescu. Please.
Thank you. I don't think it works. It does. It works?
Yeah.
Yes, now. Yes. Thank you very much for inviting me here. It is a discussion among mostly lawyers, so I will try to bring in a bit the approach of an economist. And I would, generally speaking, agree that the market sets the wages, not the employers. If they try to do so, they end up in various types of failures, particularly in the case when the pool of talents is rather limited and the likelihood to find well-educated people is as it is. But I should say in the same time that there is no evidence that the significantly more rapid increase in wages in our country, and for a good number of years now. So just to remind you a number, in 2000, the average wage in Romania was 100 euros. Now is 1,100 euros. We are talking about a huge increase in this period of time. What happened? First of all, it was a dramatic change in the structure of the economy. In 2000, we were still a lone country, a country which produced textiles in loan. It is no longer the case. For the structure of the economy now, it seems that the rapid increase in wages did not actually hurt our export capacity. Our exports kept growing in spite of a significant increase in wages. It was true and it still is true, that we had a higher deficit in the balance of payments. But as an economist, I would argue that the cause of the external deficit is not the increase in wages, but the deficit of the government. The two of them, the twin deficits, go precisely hand in hand. Once we have a high deficit of the government, as we do have now, and we are almost unable to reduce it, we end up in having a high external deficit. So regarding the risks of inflation due to higher wages for well-educated, skilled labor force, it doesn't appear to be there. I have another set of evidences for that. Is one of the things that I was looking is an indicator which is called the Economic Complexity Index. An index which measures the relative knowledge intensity of an economy or of a product. We had an extraordinary increase. We were far behind all the other countries in 2000, 2001. Now we exceeded quite a lot Bulgaria, and we are near the other three countries in Central Europe. Besides, the level of profitability in our economy did not decrease. We have the two industries that I was more concerned about, and I should say, I don't know if it is very, very diplomatic, pissed off, seeing what happens is that we had two industries that had a fabulous return on equity for a good number of years. The two industries are IT and constructions. They are at about 40%, to give you the number. So 40% return on equity is fabulous. It's absolutely fabulous. Unequivalent anywhere in the civilized world. The two industries had fiscal incentives. This is insane. Simply insane. The IT had incentives for 25 years. It disappeared only in January, and I had a lot of fights personally with various IT staff saying that it was unfair because they should have been announced in advance, and that the business plans are ruined by this. My answer was that the incentive had remained below 8%. It was 7 point something percent of the wage bill, not of the costs of the company. And at this level, reducing this incentive does not change profitability. And if we look across the ocean and we see how tariffs could be changed yesterday and today and tomorrow, I should say that probably we are pretty well with our things that change. However, we do have the trouble of inflation. The inflation is higher in our country than in others. Hungary is the one which is above us, and is a very is an interesting case because Hungary has experienced for a good number of years the illiberal policy promoted by the government of Hungary, which included a number of measures which were meant to reduce inflation and to increase the welfare. But those measures were so bad, I was about to say stupid, but I will not say. So they were so bad that the impact was that they had a lower growth, higher inflation, and worse results in economy. We have the second largest deficit in the EU, with something around 5% currently, which is to a very large extent due, as I said, to the deficit of the government. Without the deficit of the government, inflation would go down by itself. What the central bank does for that? Well, we try to be predictable, and we have our instruments used in a way that the market trusts that we are predictable. Exchange rate, interest rates, liquidity in the market, the three instruments that the central bank has have been used so far in order to keep as steady as possible developments, including in inflation, in the economy. But with the elephant in the room, which is the deficit of the government, it will be rather difficult. Now, regarding the labor market, I should say that we still have room to be more flexible. As an employer, I could tell you that it's by far more difficult to get rid of a bad employee than to hire a good one. We have enormous exit barriers, and every single exit barrier becomes instantaneously an indoor barrier, which limits both the capacity to hire and the capacity to pay the employee as much as he or she would deserve. And I must say that this is happening also in Europe versus the United States, because we have more or less flexible rules in the labor market, by far less flexible than in the US. And the result is that for similar jobs, wages are significantly lower in Europe than they are in the States.
Okay, so thank you very much for that. We'll come back to you, Mr. Vedulescu. And it's true that here in this room, the lawyers outnumber the economists by 2-1. But online, I think that it's the other way around. We have more economists than lawyers, and one of them who's, let's say, an undercover economist is President Bogdan Chivițoiu, President of the Romanian Competition Council, who joins us from DC, where we're happy to learn he has passed ICE controls safely, which is something of a success for Europeans nowadays. But I understand he was the victim of airline mishaps, which is why we will just hear Mr. President speak and not see him. I have to say that I've known President Chivițoiu for a very long time. He was a professor of mine in university, but since then he was not only a professor of public policy, he was a presidential advisor for many years. He was the head of the Romanian delegation to the EU Economic Policy Committee. He's been the president of the Romanian Competition Council for 16 years. And he was recently appointed vice chair of the OECD Competition Committee, which he just started. I could speak a lot about Professor Chivițoiu and his accomplishments, but now I would like to ask him, how does he see the enforcement of this? We know that the authority has some investigations which are ongoing on this labor market. Does he intend to have more of these? Does the authority plan to have to look at these differently, or just bundle them up and under the restriction by object label prioritize a quick policy enforcement of these? Please, Mr. President, I hope that you can hear us.
Well, thank you very much. I can hear you with some hiccups, so I hope you can hear me well.
We do.
Even if I have to say, oh, Paul, can you hear me? Is the connection good enough?
Yes, we can.
Okay, good. So I'm very happy to be with you. I'm flattered by the introduction, and I'm only afraid that I'm going to disappoint you, because all these great words raise expectations, and I'm afraid I'm going to be I won't be able to raise to the level of this expectation. So listening to the debate so far, I'm afraid my prepared remarks will be rather simple-minded, because honestly, I don't see, and so far the approach of the authority does not distinguish no poaching agreements from other type of buyers cartels. Whatever arguments there are about efficiency, or whatever pros or against, I think could equally be raised against any other type of or concerning any other type of buyers cartels. Our approach so far has been to, again, the way we are thinking about enforcing, we haven't passed any decision yet, but the way we approach enforcing is to see them as agreements which are by object, they are clearly harmful, and if there are some efficiency justifications, they should be brought by the parties, not by us. So again, I would say that's a bit simple-minded. Maybe boring, but I'm always afraid of paralysis by analysis, and a bit of a skeptic by nature. I'm also a bit skeptical when I hear lawyers telling that needs to be more economic analysis and more economic justification of things. It might very well be the case, but I think it's up to the parties to bring these economic justifications and efficiency justifications. And the only thing I can promise is that we'll be open-minded and will listen to this type of arguments, even if I have to confess, I don't think that in those many years that Paul has mentioned, we have ever accepted an efficiency argument for a horizontal agreement. Of course, all these other things that have been talked about before, how do you prove agreements and so on, they are valid, but they are valid for any other type of agreements. It's difficult for us to prove agreements without having evidence of communication between parties. It's not impossible, but it's rare. Yeah. So, but this type of objection of arguments, they could fit any type of an agreement. Yeah. So I don't see anything in the nature of poaching agreements that justifies them being treated differently. My last point, to leave the door open for a bit of hope, is that I see things differently when we talk about non-competes. Non-competes seem to me a much less clear-cut issue, both in terms of economic efficiency, but especially of legality. Non-compete issues are now at the forefront in US. OECD wants to look into them. There I really have I keep an open mind, yeah. So I don't really know if there needs to be some regulation or if there has to be and if that regulation has to come from competition authorities. But coming back to the topic today of no poaching, this one seemed to me much less controversial in terms of economic harm and in terms of legality under competition law.
But if
I
I
could
may
help in any other way, Paul, let me know. If you want me to, please do.
I do have some questions, and one of them
Okay.
One of them is, I remember that because your authority is not only concerned with enforcing competition law, but also unfair competition law. And I remember that there was a provision in the unfair competition law that said that if someone came and took my employees in order to destabilize my company, that would be an unfair competition act that I could act against. And when the transfer of authority for enforcing unfair competition law was passed to the Competition Council, the authority made well on its intention to eliminate this specific unfair competition act from the law. And then there were a lot of questions as to whether the unfair competition law could prove an alternative remedy for employers who feel that they're being attacked systematically in order to be destabilized. And there was this question, this idea was touched upon by professors Jeffers and Marinescu earlier, saying that you should have some form of protection for the employer in case there's an attack on the core of its business. And they were mentioning NDAs, they were mentioning trade secret protection, they were mentioning a lot of things. But we've gone through these in Romania, and they were all under the unfair competition law, employees using confidential information on the employees they had obtained during their employment in order to destabilize their former employer, not taking key employees whose salaries they knew in order to block their former employers from performing the contracts they knew they had to perform. In the unfair competition law as is, there's no such protection against the destabilizing by poaching of key employees. Do you feel that there should be some sort of protection? Do you feel, because I understand that there's a reticence to allowing any form of protection against this poaching of employees, but there are cases when either the employees themselves, under the guise of the non-existence or non-enforcement of non-solicitation clauses, or under the form of the non-enforcement of non-compete clauses, they do poach these employees by using confidential information or by using knowledge that they had previously acquired. Do you think this would be something that the authority could look at on the other side of pursuing the no poaches?
Well, not so secret, Paul. We touched a bit on this topic in the sub-panel that we had while we were disconnected from you. Yeah, so those who were on the internet only, we discussed similar topics. Yeah, while waiting to be back in touch with you. My view on this, one, it's me who took off the legislation of unfair trading practices, the provision on disorganization. Yeah, I did not find it justified to have it as as an illegal behavior to poach employees from competitor or non-competitors. Yeah, to be a bit provocative, I would say now publicly what I said sometimes privately, serfdom has been abolished in Romania somewhere mid-19th century. I don't see any economic or political reason to reintroduce it. You want your staff not to leave, treat your staff well. If they find a better employment, that's very good, yeah. This is more efficient, yeah. If people move in better paid jobs or better conditioned jobs, that's probably more efficient. They're more efficient there. Yeah, so I don't see any reason to block people moving from one place to another. So now this explicit provision no longer exists under unfair competition law. However, this unfair competition law leaves open to the lawyer's imagination, unfair trading practices. So we say that now what are clearly mentioned there, so this organization is no longer there, it's just spreading bad rumors about your competitors or stealing clients. Certainly, so the turnare clientele, which try to translate it into English. So it's clients being detoured or something like this. These are the only things that are specifically mentioned in unfair competition law. But also, there's any other practice which is against good morals and the usual practice and so on. So under this open-ended clause, maybe you could find a case where some type of no poaching behavior could be considered to be unfair practices. We'll see about that. And as I say, it's up to the imagination of lawyers to come with concrete cases. What we do, whatever I think there are justified issues related to movement of employees, I think they're adequately dealt with other legislation. Trade Secrets Act. That's an EU directive. So, of course, companies have the right to protect their confidential information, and they have the right to expect their employees not to divulge this information to their competitors. So that's reasonable, legitimate, but it's covered by Trade Secrets Act. I don't think we need special action by the companies, or no poach agreements or whatever. Companies have to rely on the Trade Secrets Act, and they could use courts to enforce that. And also, we accept these type of restrictions as justified, as long as they are covered by the trade secrets. Secondly, if you invest in employees, you send them to expensive training and so on, labor code allows you to have an agreement with that employee not to leave for a while or to compensate the company for the expense. So again, I think this issue is adequately dealt with by the labor code. I don't see why companies could justifiably enter secret horizontal agreements, when they have adequate legislation that should alleviate their legitimate concerns.
Okay, and I'm just going to insist a bit with you because I know that you have a meeting that you need to get to, and I don't want to keep you too much. But I would like to understand whether you think the authority should pursue not just by what the law qualifies as employment relationships per se, or whether you think that these types of limitations could also apply in respect of freelancers or people who are in copyright related agreements or in other forms of collaborations. Do you think that this competition law review could be extended to those markets as well?
No, I think it fits better in those markets. So, being half loyally, as loyally as I can, I find it more difficult for us to intervene in labor relations, things like non-competes. And I find it somehow easier to get into what could be legally easier construed as vertical agreements between companies and other undertakings, be it Yeah, very small companies, single employee companies, and so on. So, if there is room for us competition authorities to look at non-compete agreements, I think would be easier legally to justify them if we go to this type of relationship rather than to purely labor market contracts.
Okay, thank you very much. And on this, because I find this a bit, related to what was being discussed earlier, related to the fact that the enforcement should focus on the secret agreements. Now, it happens that in these other agreements, namely the freelancers, the copyrights, the professional sportsmen, everybody else. These are normally agreements negotiated individually, so the restrictions would be much more openly discussed than in the employment scenario. So do you feel that then this could, let's say, ponder, or this could give pause to the competition enforcement of these agreements if in let's say in the law firms, they have contracts with their lawyers. So we don't have employees, we have contracts to collaborate with our lawyers. So our associates are collaborators to our firm. And if we would have these limitations in these contracts would be negotiated with presumably very smart lawyers and who understand these limitations. Would the competition authorities then want to intervene in this case, or would they feel that the direct negotiation of these limitations and the acceptance of such, the consent, should give them pause to do so?
But the question is still for me, yeah? Paul, just to make
yes,
sure.
Just because I still have about 3 minutes left of your time.
Yeah, Alessio has a stronger view than me on the distinction between secret and non-secret agreements. Yeah, I would be more of the view that agreements as such could be, if they are anti-competitive, yeah, they are under our or it could be our task to deal with this kind of agreements. And I would agree that making it secret makes it more suspicious. Yeah, but by and large, I think any agreement that restricts competition, it's like agreements between undertakings. So that's why I think we get loyally. Is it which qualifies as an undertaking? Which contracts qualify as labor contracts? Therefore, because labor, I would not see undertakings. Yeah, and individual worker being as specialized as whatever that worker would be. Yeah, it's not an undertaking. When does a single, basically a single employee entity, when it becomes an undertaking? Yeah, I think that's, you are the expert there more than I am. Yeah, but the priority, I think, would be easier, for practical reason, be easier to deal with this type of situations, yeah, where we could qualify people as undertakings, yeah, and not purely labor relations.
So I think
it's very difficult to talk in hypotheticals. Yeah, I don't really expect us to target law firms and the relations with their employees. Yeah, so this won't be a priority for us, but also depends on complaints that we get. The fact is, we've been reacting. Yeah, even we looked at no poaching. We looked at no poaching for some time, but when we finally opened both cases that we have, both the Dacia Renault case, which is a bit older, and the new one on the dentist, yeah, they are because of complaints, of quasi-complaints, yeah? So information from the market. Yeah? So if some people feel mistreated, they might write to us, and if we see merits, we might look in the case. But again, I don't see, you expect lawyers to be sophisticated enough and not quite victims, let's say. So I would not prioritize relations between associate lawyers and their firms as an antitrust issue. My final point, what I wanted to say here, try to be a bit provocative. I don't see no poaching any different from any other buyers cartels. Yeah. Where they are a bit different. Yeah, it's not in technical part. It's technical term. It's more in the public relations, in the political part, because of course we do in Romania and everywhere. Yeah, we do lots of cases. But in terms of public communication, we try to simplify what we do. So normally we try to tell the public that we are there to make sure that prices are not increasing. So that's our selling. The selling point is normally that through our activity, we stop companies colluding to increase prices. With no poaching, we have another good line to say. We are stopping companies colluding to keep your wages low. So from this perspective, no poaching are more interesting. Yeah? So not in the purely technical and legal sense, but in terms of presentation, justification, legitimacy of our work, I think they fit very well. Yeah, and that's why we'll be very willing. Of course, we do cases with more consumer impact and less consumer impact, but given a choice, we look into these cases which are sellable from a public opinion point of view.
Okay.
But it's a very personal. Yeah, I have Alessio on the screen, and he looks worried a bit or something. So this is it's a purely Romanian point of view. Doesn't imply anything about any other competition authority in Europe or otherwise. Thank you.
No, it's a very good point. It's normal that politically it's a sellable type of enforcement, and it was just my resting face, skeptical by nature.
But I knew that Mr. Ariso had a hand raised, so he did want to intervene.
No, I just wanted to say that I did not say that if there's a cartel and.
Oh, we don't hear you. I think there's a problem with the audio. Now we can hear you.
Yeah, I did not want to imply that if there's a cartel and the cartel is entered into through a public document, that's not a cartel. I mean, look at the case of the football case in Portugal that was entered into through documents that were in the public domain. In my view, that's still a cartel. I mean, I'm not saying that if you do it in public, it stops being a cartel. But if there is a secret agreement, the point is when we're talking about purchasing alliances, they need to meet certain requirements in order to qualify as such, and not to be subject to antitrust enforcement. And one of them is that there is transparency vis-a-vis the companies from whom the purchasing alliance is buying. That's everything I wanted to say. But
thank you. No, it's very clear. It's. What I was saying was going back to what Professor Jeffers was mentioning earlier regarding the fact that the employee, especially the senior employees with leverage in negotiations, when they negotiate this clause, they have a higher clout, and therefore they're less likely to be harmed by the effects that they accept. But I will now go to the economist side, and because as a final thing, starting from what President Kivitsoy was saying earlier, that the basic point was to make sure that the prices aren't increased. I do have this question from our clients, which is that because of this, and it might be just their perception, but still. So the perception is that because of the very high mobility of workers, there is a reluctance to invest in their professional development, but rather to invest in benefits that are non-transferable. So I've had many clients tell me that instead of having their employees better their skills, so pursuing, in our cases, a master's degree or a postgraduate diploma, learning something new, learning new skills. They prefer not to do that, but they prefer to, change one of their floors into a gym. They prefer to give massages at work. They have all these new, benefits that are non-transferable. But all these transfer into costs that go into the market at the same quality of work being done, because essentially if you don't increase the quality of the employees, so their professional skills, they will provide essentially the same quality. But the prices will be higher. And they say, if I had some way of retaining these employees for the amount of time that it would be worth to me, I would prefer this investment to go into the quality of their work. And that quality of work will reflect in better products in the market that could justify the higher prices. And the perception now is that the higher prices are somewhat unjustified, and they're the effect of the race to retain a very limited number of employees and diminishing number of employees available. So how do you see, from an economic perspective, this happening? So maybe we start with Mr. Radulescu, and then we go inverse.
Well, the very short answer to this is I don't see it. The fact that investing in a better skill of the labor force is definitely good for a company. If the case may be, the company could set the rule for the employee, for a specific employee which gets some additional courses or whatever, a clause in his or her contract in which says, for having this course which was paid by me, you either stay with the company for, 2 or 3 years, or if you leave before that, you pay back pro rata the amount I invested in you and I was not able to recover because you left. Generally speaking, as an employer, I always preferred to have better educated persons and to help them perform better. And the result was, in most cases, that I had better results overall. And more than that, it is the market which, for a specific level of positions, the market tends to find out that you are a good employer or a bad employer. You are an employer which wants to support you or doesn't want to do so. I remember once I was speaking to an architect who worked in London. He was Romanian, he was educated here, he got a job decently paid, but not that much, and he got the promise that his result in the work, which was easily measurable, would lead to an increase in his benefits. Well, at the end of the year, he ended up of not getting the benefit that he expected to get. The next year, he worked precisely the amount for which he was paid, and he got another job in the same time. You cannot, when you have good employees, you cannot mistreat them. If you do so, you shut yourself in the foot. It may not happen immediately, but eventually you are going to pay if you do so. So I don't think that not paying for education and paying for the gym would be very, very useful. I would suspect even that a free ticket to the gym does not lead that person to go to the gym as often as if he were to pay for that.
I can personally attest to that. So, I would actually go from this to Professor Marinescu, because this was actually one of the questions that I wanted to ask her, because her research centered on the idea of the monopsony of the employer. And I was wondering whether you looked at it as on the other side, as a monopsony of the employee, because what we're looking at, is a very, again, what everybody perceives as a very tight labor market, and especially in very, very niche specializations. We've seen this recently, I think, with people involved in the training of AI. There were very, very few. There's an inflation of companies wanting to enter this field, and the employees then end up having tremendous power on this market. They have tremendous power to arbitrage on this market, and they can arbitrage between the employers. How do you think that changes the perspective? I noticed that there's a hand. I think it's Professor Jeffers. Yes, we'll go to her next.
Yes.
Please.
I don't think it makes a fundamental difference, because the way we think about monopsony power is, so we argue the definition is the distance between the employee's marginal revenue product of labor, meaning how much they're contributing to the company's bottom line and how much they're getting paid. And so there could be a gap, and that's what we call monopsony power, that gap, all right? It measures that. So, the company isn't going to pay anybody more than their value. So, worst case scenario for the company, it's an unpleasant situation to be in, but it's like essentially they're paying the person pretty much whatever the person is worth, and it's painful because you have to pay more. I understand, if you're the employer, that's difficult, but you're not going to pay them more, than they're worth. So I think that's in that sense, that's how we look at this issue. Now, what I think is really important with the issue of the gym, I think that's a very interesting example, because it points to the compensation package, which is very important to be looking at. It's not all about the wage. It's the wage and all the set of other benefits and circumstances that are being offered. And what research showed, and it's really interesting, is that more and more we have research confirming that higher paying firms also tend to offer better benefits in essentially every dimension. They have better gym, better food, better scheduling, flexibility, et cetera, et cetera. And so employees, therefore, are really interested on average in working on those firms. And as was just said, that's how you attract, more and better employees. And of course, usually the way this works is that these are the most productive firms. So they can afford to actually pay more as a total compensation package, not only higher wages, but also all these other things that might attract employees. And what we see also, and just to finish, is that it's incredibly important to the employees, the non-wage aspect of it. And, others have research, but for example, in my own research, I find that more than half of the utility of a job, of what people care about, is not the wage, but the other stuff. And in particular, for example, the distance to the job is very important to people. There are many other aspects. And so in that sense, it's only rational for firms to seek to offer a good job package. It's not all about the wage. It's to offer a good job that people will want, so that they can attract, especially, again, in areas that are highly competitive. They're really interested in offering an attractive overall package for workers. So that's the way that I would think about it.
Thank you. Professor Jeffers?
Yes. I think there's also a very natural limit. So I think this idea of the employee as a potential monopsony power that you bring up is, it's a very provocative, interesting one. And it is true that I'm one of the non-Romanians on this panel. It's true that, in the US, for instance, it's a bit of the opposite concern, that mainly looking over the past few decades, there's a concern that the labor share hasn't been growing. And so that does set the context for a lot of the research that we've done. But this is what I will say about employees potentially representing a monopsony or being or having hold up power over the firms. There's a very natural limitation to that, which is that new people come in all the time in a way that is not true for the flip side, right? So for firms, firms are born all the time, but we do worry about conditions that make it harder for new firms to be born. And in fact, that's one of the concerns with non-compete agreements, is that they depress the birth rates of new firms. So yes, they're good for incumbents, but they also have a negative effect on new firms entering. With employees, you have new people coming in, literally being born, and then graduating with maybe AI. So if there's huge demand for AI skills, yes, it may take, there might be an adjustment period, right? You may not have those highly skilled in AI people available just yet, but within a few years, if that's a skill that's in high demand and that's paying very high wages, you're going to be attracting students who then really want to study that because there are very high wages to be had in that profession. And then, there may be an adjustment period, but that should more naturally adjust, I think, than where firms and employers are concerned. I think that adjustment needs more regulatory control.
Thank you very much. I think that I'm going to have Adrian have a final go at this. I'm sorry, we're already way over the time that we allotted, but I'm going to be very brief. I've noticed a trend. So there were agreements. So we're in agreement that investment in employees could give you a limited time. We understand that there could be situations where for very niche employees there could be some leeway, and now we're discussing this, that it's precisely this lag, this time asymmetry that requires the labor market to adjust, that creates this what I called monopsony and possible arbitrage by the employee. And that's the one thing that I would add, is that I've seen many young firms, many young startups go under because of the costs they assumed for the specialized engine, because they have no other costs at the startups. And the new model for VCs is that you don't produce an income for 5, 10. You cannot produce an income for, you can be on losses for 5 or 10 years. And so I'm thinking, could this limited time that would buy you this, this security of the team that you have and that you're developing be, both acceptable from both to the authorities and to the businesses? What do you think?
It's a very interesting question, and I think we've gotten to, companies aren't. We've gotten to the good part. Companies, I don't think that companies are evil. I believe that the companies act upon incentives, and if you enter into a no-poach agreement with your biggest competitor, basically that means that both you and him, in the interpretation given by the authorities, are perfectly fine with what you have at that moment, because you cut yourself from the biggest source of talent on the market. So it is you don't only protect your employees, you're cut off from his employees as well. So
it's obviously an entrenchment, yeah.
Yes. So if you're a startup, that means you truly trust your people, fair enough. But are you that confident that you will never have the need for somebody else from the market? Are you like, yes, we're good. The people in this room, we've got this. No matter what happens in 2 years, no matter how the market changes, we have this. There's nobody else that trains people better. There's nobody else that we want to recruit people from. So I think this is why you have to look at no-poach agreements as rationally justified from, and to look for the rationale. And to companies, I'd say, if you enter into a no-poach agreement, the advice that we always give is leave a paper trail as to why you're doing it, because as you see,
Don't poach.
well, don't do it. Don't ever do it. Talk to your lawyers. Don't do it, and then talk to your lawyers, and then don't do it. And if they tell you to do it, don't do it. And if they tell you that it's an ancillary restraint, don't believe them. But if you have to do it, then you have to have a bulletproof justification, and you have to have it documented, and it has to make sense. You have to identify the project that you're doing it in connection with. You have to identify the employees. And it has to be, as we like to say, contemporary to the time of the decision. So it carries more weight if we have something done there justifying your decision. But, I'd like to say that your solution would work for the authorities. I'd be lying. That doesn't seem to be, but.
Okay. Well, with that, I want to thank our panel very, very much for their time today. Apologize for having taken significantly longer than I expected to, but the discussions were really, really interesting, and I hope our participants, both online and here on site, had a very informative time. And maybe some ideas will be born out of this that we'll be discussing in the future as well. So thank you again, everyone, very much. And I look forward to seeing you again on the next occasion. Thank you.